Hey, all you ethic cuties and the 40% of you who have still not subscribed to the Ethicsverse, welcome to the coolest place to be. Even if we're 5 minutes late, I apologize. Had a couple of camera issues here, but we are back at it. We are ready to dive into an exciting session today. 10 top mistakes for leaders, legal missteps, and management blunders. So here's what we're going to cover. In the next hour and 5 minutes, we're going to dive into some of the biggest legal missteps that leaders make, why they keep happening in every organization, even those with strong policies. So we're going to explore how, everyday management decisions create, various different types of exposure, the routine stuff that doesn't really feel risky until it is. So, and we have the one and only James Reid here. So let's get a massive emoji explosion as my cortisol starts to drop. I've been cortisol maxing for the last 5 minutes here. Let's welcome James Reid, and I'm going to run in here through a couple of quick announcements. So welcome to the Ethicsverse. We're, of course, going to be giving away some books. We're giving away today the FCPA Survival Guide by the one and only Tom Fox. So if you have not checked this out, you should win a book today. And if you don't want this book, then you can pick from any of the books in the library. We are, of course, giving out a bunch of credits as well. We've given out hundreds of thousands of credits over the last year, and we're going to keep giving out some more today. The 2026 benchmark report has gotten phenomenal feedback. Thank you, all of you who have shared it online, who have sent me DMs, have let me know how much you like it. This has been a labor of love, and there's a lot of great findings in this report. So if you haven't checked out our episode with the one and only Ellen Hunt, one of my all-time faves, go on YouTube and check that out, or you can find it in the console here. And if you have not downloaded this and shared this with your team, or better yet, download it and just take some of the hints from it yourself and then show up to your team as somebody who's super smart, you should absolutely do that now. So the links should be in the chat. Somebody learned how to put bold in their chat, which is awesome. Great job there. But download this report, share it with everybody else. Thank you guys all for your patience. Of course, I hate being late to things and really appreciate everybody sticking around. We've gotten a lot of great feedback on the AI native third-party risk management. This is revolutionizing this entire process. We talk about going from 2 months to 2 minutes, and the people that are starting to get involved with the beta are actually, showing that that's actually true. So if you're interested in joining the beta, we still have some more spots open. But this is an area that kind of contains a lot of risk and is a very sort of AI-able thing. So the whole premise here with this platform is that AI does the work and you make the decisions, and you can we can customize this entire thing for your process, for your team, for the types of things that you want to be screening against, the recurring, monitoring and all those kinds of things. And you can really cut out a tremendous amount of the manual work that is not really an application of the unique skill set that you've built over your career and what you were hired to bring to bear inside of your organization. So look at this thing. It looks freaking amazing. Absolutely love it. Getting some great feedback on that. So this is up. If you want to do the QR code, you can fill out a form. Somebody from our team will contact you and we'll hop on a call to see if this might be a good fit, or if you just want to wait until it's ready to be fully commercialized. But appreciate all those of you who have participated and all the phenomenal feedback that you have provided so far. We talk a lot about how we can improve our program, how we can drive more impact in our organizations to build these sustainable cultures of integrity that can ultimately actually improve the bottom line in our organizations by driving more engagement. And we know that ethics and compliance and human resources and employee relations cannot exist without people. Well, why don't people interact with us? Well, it's this fear of retaliation. And that's the number one reason that prevents people from participating. I've referenced this 1,000 times. You guys should be able to regurgitate what I'm about to say here. But ECI's report year after year shows that over half of the people that speak up face some kind of retribution. So that is a massive headwind for getting access to the risk intelligence that exists within your organization that you need to make better bets with your time and direct your resources towards the things that are going to drive the biggest impact. So structured retaliation prevention is your salve to that burn, is your fix for that kind of a problem that we all face to some degree. Look, even if you're twice as good as every other organization, that's still 1 in 4 people that are facing some kind of retribution. That is an easy elephant in the room to address. That is an easy thing to kind of fix when you can structure anti-retaliation policies that are brought to life in your actual process. So standardized formats, automated follow-up, and real-time analytics can give you an insight into hotspots that, like Ellen was saying, hotspots inside your organization where retaliation might be an issue, and where you can put some communication or some follow-up in place to show people that your commitment to anti-retaliation is real and it's not just some words on a dead policy. Okay. All right. With all that, let's give a massive emoji explosion to the one and only James Reid. All right, we're back on our feet. Okay, we hit our mark in 5 minutes for those announcements. James, how's it going, man? Welcome.
Oh, it's going amazing. So happy to be here. I feel enlightened having this great group with us today.
Very good. Well, hopefully you can share some of that enlightenment. All right, so we're going to dive right in here. We got James M. Reid the fourth. I haven't met many fourths, so that's a pretty impressive name, James.
My son, James McGregor Reid the fifth, is at home, so the pressure is already off me as well.
He's at Honigman LLP, and we're going to be talking about this thing that like I was saying in the introduction. Our organizations are not full of rogue actors. It's full of well-intending leaders. There's everybody on this call are the kind of people that are trying to make the world a better workplace. They're trying to leave the world better for the generation that follows and the stakeholders that they are, entrusted with. But behind all these kinds of charges that end up, these harassment claims and these issues that end up happening, there's usually a leader who thought they were handling things correctly. And so James is an employment attorney. He brings a tremendous amount of perspective from a practitioner's perspective to the types of compliance failures that are sort of hiding in plain sight. So I want to just kind of dive right in here. James, let's kind of set the stage a little bit. You work with employers every single day. What do you think is the most surprising thing compliance and HR professionals consistently underestimate about their legal exposure?
Absolutely. So it's by far the concept of at-will employment. So most of the 50 states and other countries, you can fire somebody for any reason or no reason, as long as it's not any legal reason. And a lot of the times, the manager doesn't want to engage in conflict. So they just say, you're fired. I'm not going to tell you why. There's no reason at will. And that is a major landmine, because you're basically allowing the employee to think they're perfect, did absolutely nothing wrong, and they're being let go. And there are other employees at the company that are not perfect, that have made mistakes, that are still there. So it kind of goes back to the Warren Buffett famous quote, which is, the most important thing to a relationship, he jokes, is low expectations. And if an employee expects some level of fairness or respect and you don't give them that, they're going to not take accountability and want to sue.
So, why do you think people end up missing that so much? And, I love that quote, and that's kind of such an accountability killer, to your point. But why do you think we kind of lose grip on this sort of aspect of employment, which obviously leads to a lot of the, negative externalities that we'll be, diving into throughout this conversation?
It's really because employers honestly don't think they're engaging in illegal discrimination. And frankly, over 90% of the equal employment opportunity charges of discrimination filed, there's no evidence of discrimination. But that's where the employers make the mistake. Just because there isn't discrimination and there's no evidence of discrimination doesn't mean the employee won't feel what happened was unfair, or they won't understand why they're separated. If they're ever surprised, all of us are part of multiple, what's called a protected class. So if any one of us are surprised or felt the separation was unexpected or unfair, we have several bases to bring claims. And even if we're not even able to prove it, we're still able to get $10,000, $20,000, $30,000 in a severance agreement, because just having a factual dispute is going to cost more than that litigating.
So in the pre-show, you kind of made the point that most costly employment disputes, they're not starting with bad actors, they're starting with meaning leaders that operate on assumptions rather than actual knowledge. And I think that there's this gap between what organizations, kind of to your point, think their policies are saying, how managers are actually applying them, and then the day-to-day, perception, I guess, on the employee side on where those sort of policies live and how they end up living out.
Yeah, that's so true. I think too many managers think by being an empathetic ear and saying, yes, that person was disrespectful or unfair, they think they solved that problem, but really they didn't. It still getting built up day after day. And if that employee ever moves on, they often want to bring a claim.
So we got a great question here from Andrea. Is there any data on when an employee sues without known cause of termination? Do we know if the data shows more favorable to the employee in these kinds of cases?
Well,
great question.
Someone in the chat already posted 96% of EEOC charges reported don't substantiate any level of discrimination. So that goes to show you that if you don't lay out all the clear performance issues, typically with 3 strikes like baseball, they are going to think they're being treated unfairly. And I think to the point of the audience, people think unfair means discrimination, and that is not the law. It has to be treating you that way because of your protected class. If they just treat you unfairly because you aren't performing well, or they don't like your attitude, or you're not growing at the level they would expect based on your experience, those are actually legal reasons to separate. And so therefore, employees don't understand that. They just think unfair, I should sue.
I see. Is there a time frame required? This is from Nancy. Thanks for this question, Nancy. Is there a time frame required for the employees to bring suit?
Yeah, so typically, yes, the answer is yes. And it depends on the basis of the claim. So in some states, a breach of contract could be up to 6 years. For discrimination in federal court, it's roughly 300 days or a year. For state law claims, it's roughly 2 or 3 years. What a lot of lawyers do is they get employees to reduce the time period to sue to 180 days. And in many states, it's legal, if you disclose that to the employee ahead of time, to narrow the time frame in which they can sue for some state law claims. Some federal claims can't be reduced, but in general, at a big level, 6 years or less.
Okay. So we kind of like scratched the surface on this before. I want to kind of dive into like the anatomy of a compliance failure. And what are the things that we as an audience, or we as ethics, compliance, HR practitioners can start to think about, or enable middle managers where a lot of this risk might live, to kind of close the gap on these risks that kind of are probably exist to a greater extent than we can imagine within our organization. So like so many things, I want to kind of start I want to start with mindset. What is that current or common mindset or assumption that gets these well-intended, managers into legal trouble? Is it, let's just kind of start there, and then we can kind of dive a little bit deeper.
There's 2 main reasons that I see. One is these middle managers are quick to make conclusions, like this employee sucks, they're bad. And they'll then notify HR their conclusions. So then sometimes HR does a preliminary investigation and ends up separating that employee using a buzzword like underperformer. And by making these conclusions without having documents that support the facts, that employee can prove, well, no, I wasn't the worst employee. I had a review that said I was average, or I can show that someone else was less productive than I was. And if they prove your vague conclusion isn't exactly true, that's strong evidence of pretext for discrimination. And then second, I would say that over 90% of managers don't even know the protected classes in their jurisdiction. So they don't even know, like, just a random example, I'm in Michigan today. Height and weight are protected classes. So if I made a joke about, eating too much, or being skinny or tall or short, managers don't know those are protected classes. And when they joke around like that, an employee, when it's time to, be held accountable for a performance issue, they're going to remember that joke and say, my boss has a bias. I have evidence of him using bad jokes on protected classes.
And those jokes can go either way, too short or too tall, too heavy or too thin, probably.
Yeah, that's right. Too old or too young in many states. You're right. It's a very broad range. And step one would be, what training did the middle manager have? And if the answer is none, any investigator is going to assume you're violating laws left and right.
Right. Somebody mentioned that military veterans is a big one. Is that covered kind of everywhere? What are some of the big ones that are kind of covered everywhere so we can start not making those kinds of jokes?
Yeah. So starting at a federal level, veteran or protected class, you could say age, 40 years of age or older, you're deemed to be an older protected worker. Sex, race, religion, disability are the main federal. And then at the state level, it depends on which state you're in, but typically sexual orientation, gender identity, misdemeanor arrest record, whether you're married or single, whether you have family or you don't have family. So like during COVID, a lot of people that didn't have family were asked to come to work, but if you did, you could allow someone to work remotely. Well, that would be illegal. You can't make decisions based on protected classes.
The chat is blowing up here, so thanks for all those questions, guys. I'll get to those in a second. How do you distinguish, James, like between a manager who makes a genuine mistake and one who is sort of more nefariously kind of creating a real organizational liability? Or does that distinction even really matter once it gets sort of elevated, in one of these situations?
So the distinction doesn't matter as far as employer liability. This isn't criminal law where you have to prove their first degree intent versus second degree versus reckless. Either you are guilty, even unconsciously, by a preponderance of evidence. So a preponderance of evidence means like 51% likely guilty of factoring in a protected class, whether you were aware of it or not. Where criminal law is beyond reasonable doubt, which is like over 97% able to prove that they did that act. So basically, it doesn't matter what your intent is from a liability standpoint, but whether or not I want to fire that bad actor that made a mistake. If it was a good faith mistake, maybe I'll give them a second chance. If they're really negligent or reckless, it's probably time to hold them more accountable.
So let's get like really practical here. I appreciate that insight. Let's get practical here. So let's say that you're a compliance professional and you suspect a manager is heading toward a problem. Maybe we've seen a clustering of kind of, gray zone type comments about a particular manager in our exit interviews or in our stay interviews or just coming through the hotline, but no complaint has been filed yet. Like, what advice would you give, somebody in this situation on like what the best sort of most effective first step they should take, to limit any potential liability that might sort of spring out of this situation?
Great question. So step one would be have a panel that makes the decision, because that way, if it was you and me and maybe one more person, what are the odds that all three of us have the exact same potential biases? And maybe there's someone that only reviews the job related facts and doesn't have all the knowledge of all the other potentially inappropriate activities. So there's this theory where even if you are a bad actor, you get an outside expert or an independent investigator that figures out this person should be let go based on performance, that's a slam dunk defense to any claim.
Gwen has a great question here. Thanks for this, Gwen. What if an employee is put on probation and have shown that they have improved and worked with HR for improvement, and they're facing a hostile environment, but they still get let go? Is the company still liable? And you can't say it depends. Just kidding.
I will not use that word, I promise you. So a hostile work environment usually requires 6 or more pervasive comments based on a protected class. If it's just unfair or an equal opportunity a-hole, that is not a hostile work environment under the law. And even if the employee thinks they're a rock star and they're a great performer, it doesn't matter how good they think they are. If leadership thinks you're not growing at the rate they want, there's what's called the honest belief rule in most states. they can believe you're not a good worker, even if you are, and it doesn't matter. They're allowed to make bad decisions as long as it isn't for illegal reasons.
Interesting. All right, let's kind of jump into, everyday decisions that create this legal exposure, because, again, so much of our audience are ethics and compliance, human resource folks. We're kind of meant to be, finding risk, mitigating risk that exists in the organization. Some of these risks are a little bit harder to find. If you have an FCPA violation or a conflict of interest that, could be uncovered from a form, or somebody, raising their hand about a code of conduct violation, coming through your hotline. Those are kind of like easily identifiable, like clear red flags that you want to, attack. Some of these risks that we're talking about are kind of latent exposures that, it's like, those old stories where a building would burn down because there's a bunch of like old newspaper in the basement or something like that. Like, right. It's that kind of a risk, So I want to kind of talk about what some of these latent kind of exposures are, or these like everyday decisions that, add more, newspapers to the basement. For those of you who are old enough to remember what newspapers are.
I love that analogy. So at a high level, what I would say is just do the smell test and say, is there a perception based on the timing of separation or the surprise, where maybe someone may feel it's unfair or not based on performance? And if you live by the perception is reality, regardless if it's true, mindset, then you still would have no worries as long as there isn't an adverse action. So like people are writing in the comments, they're 4'11". If someone jokes about my height, that could be an icebreaker. It doesn't really matter. I agree. It doesn't matter until they're paid less, or they're fired, or they're demoted, or have some adverse action. So I think jokes happen. Maybe just do a policy reminder. You don't need to do a thorough investigation. Maybe do a training. But before you take an adverse action, let's double check and make sure there's no perception that we are making this decision on a sloppy basis, and have some real reasons, job related, as to why we're making this decision. And ideally get a panel of several people and not just that one bad manager.
I've been talking about the value of exit interviews and stay interviews for, many years now. And this just kind of reinforces that in my mind, that there's so much of this risk intelligence. Like, it's not like, somebody gets let go and they do an exit interview. It's not like every single one of those people that are sort of on the other end of a quote unquote adverse. Is an adverse action just like firing somebody?
That's a great example of one. It could also be, paid less, or.
Yeah. Okay.
But yeah.
So any kind of an adverse action or anything that somebody is like maybe perhaps upset about, it's not like every single one of those people are going to kind of bring suit against the organization. But if you're getting some kind of statistical sampling, some kind of a participation in these stay or exit interviews, it's such like a ripe point of risk intelligence that you can kind of get out ahead of, and then you're not kind of living in this reactionary zone. So many of us on this call feel like we're always just kind of putting out fires, and we're living in this kind of, reactive mode, when we can get some better insights into those things. If you can get your finger on a pulse of a general sense in a particular department, or a plant, or a certain location, or a certain manager, if there's a clustering of people that feel a certain way, then that's an easy way to get in front of it and kind of give that person some more training, or make sure that they understand that short jokes aren't right, or, you know what I'm saying? Like, kind of get out ahead of the thing.
What you're really saying at a high level is culture is important. And if you have a culture of doing the right thing, and I kind of call the stay interview a no quit policy. Before you consider quitting and giving your 2 weeks notice, please work with us and give us a chance to fix it and do what's right. And by having this open door, continuous improvement committee culture, where everyone is part of our committee to bring solutions, be a fountain, not a drain. And we'll take all good faith proposals seriously. That better culture can make employees 50% more productive and stop people from leaving if they think there's a chance they can be valued, seen, and heard when they're going through a hard time.
Yeah, I think that's a great point. I like how you kind of tied that into culture. The problem with culture from a corporate perspective is that a lot of people think they can just kind of set it and forget it. Or what are you talking about? We have a great sort of code of conduct. Look, we have team events every month or these kinds of things. Those, of course, can be they can help the culture. But I think when we can start to think about culture really as just like the trailing 60 or 90 days of like vibes in the company, and think about culture less as something that, is like a light switch, or, what I'm saying, like a battery that like we've changed recently, but rather think about it like the reaction that is a like bonfire. I think it forces us to think about it a little bit different, right? Like if you've ever tried to camp overnight, well, you better keep putting some like logs on that fire, or that fire's going to die down, and then you're going to be, freezing. But if we're thinking about our culture, like, okay, I have to keep this kind of fire stoked. I have to keep kind of checking on the fire, making sure that there's enough quote unquote fuel. There's a great case for those kinds of things, whether they're just kind of conversations, in the hallway, or setting up, you don't have to use an outside provider to start to get some fingers on the pulses. Right. You know what I mean?
So the modern culture is they have a policy: no sharp elbows, no a-holes. They know good energy is contagious, and they want everyone at a management level and above to be part of their evaluation is how well are they bringing that good energy and building relationships with other people, and not just being good at their individual skill set. And with AI, we're able to analyze based on word choices people are doing, how productive they are and motivated, who is likely to quit within a year. And we can get a gauge on how well we're maintaining our 60 to 90 day culture. And I just attended a national conference, and they said the most important influence over an employee's mental health is not their spouse, not their kids, not their therapist. It's their direct report manager. So if you realize the power you have of someone's well-being, that might allow you to put in a little more effort to just check in with them and try to make their life a little bit better. Don't just tell the subordinate employee, here's what you do under my rules. Ask them, how can I help you also accomplish your career goals and allow you to be more productive in the workplace?
I mean, to that point, right? Like that's great advice to any of us who have, direct reports in our sort of little corner of the world. But it's also great advice for us who are risk managers or risk mitigators across an organization, to the extent that we've underestimated what impact, both from a risk standpoint and from an engagement standpoint, that managers who are not properly trained, who don't have, the right sort of principles kind of being applied in real time, can be having on ultimately the bottom line and the level of sort of latent risk inside the organization. So again, like we talk a lot about on the show, the importance of and the value of bringing middle managers into the fold as sort of a better conduit for the type of risk intelligence that like we, need in order to do our jobs, whether again, it's HR or whether it's compliance. But, there's like another side of that coin where these folks are, kind of, perhaps let's just kind of assume positive intent in, creating, potential liabilities in the way that they're interacting, because they're not thinking about that level of power. That's a phenomenal, that's a really kind of eye-opening stat you just shared.
And they don't know when to ask for help either. So I think the combination of those two things.
I got another question here in the chat that I want to get to. What if an employee is, oh no, I already asked that one. This is from an unnamed participant. These are always the best questions. How should responsibility for these kinds of risks be divided between HR and compliance? Do you have any kind of thought on that, just at a high level?
So I think you need to stage what level of claim is made. Is it a policy violation? Is it an interpersonal conflict in the department? Or is it a legal alleged violation? And if it's legal, you would need to elevate that to more of a compliance verification. But if it's more of a how to have interpersonal conflict resolution skills, that would be more HR. But it really doesn't matter whose responsibility it is. So at the end of the day, it's the company's responsibility to do the right thing. And liability wise, you want to check and see if you have what's called employment practices liability insurance that covers your claim. And if you do, you have to quickly report that to your carrier. You can't wait and try to resolve it and then tap insurance later on.
Lori, hey Lori, she said, how honest are people during stay interviews? If they have complaints, do they really share enough to be worthwhile? I'm hearing yes, but I would personally be hesitant unless I was ready to walk out the door. Maybe that's the point. From my experience, even in our company, which doesn't have, 10,000 people in it, I get a lot of benefit from it because I hear who the bad actors are. I'm just kidding. No, I hear about problems that are happening inside the organization that we can attack. And I think if the person giving that interview, has, a good kind of sixth sense, has a good relationship, has a good level of trust, they're able to get some things that, we as an organization can fix. And that, there's a handful, dozens of people that I can kind of think of over the last couple of years that have voiced actual issues, the kinds of things that I would want to hear about. And we're able to kind of fix those things, whether it's training with a manager or it's a compensation issue or, whatever. So I think there's a lot of value in it. But what would you say about Lori's point or question?
I agree with you, but I think it doesn't hurt to have more options. You could say, if for some reason you're hesitant, here's an anonymous way of how to report it. I'm seeing more and more anonymous emails coming in, identifying an issue for someone to investigate, and that employee will wait and see if they see any changes that are for the positive. So have various avenues of communication so they don't feel like they're completely, risking getting terminated before they're ready to leave.
Yeah, that's a great point. Okay, so here's a question from Allison. It's a little bit long, but I think it's really important and it's kind of near and dear to my heart. So I'd love for James to opine on appropriate efforts to prevent retaliation. Compliance officers have been advised in webinars, seminars to maintain several touch points with reporters to ensure they're not being subject to retaliation. This includes follow-up with the reporters weeks, if not months, following the conclusion of an investigation. I think this is just asking for an employee to claim retaliation. Employers should have an anti-retaliation policy that includes a process by which an employee can report retaliation. I typically advise that employers not poke the bear and leave it up to the employee, quote unquote, whistleblowers to follow the policy and report retaliation the same way they reported the alleged misconduct that led to the report in the first place. So this is a much different perspective that I think is pretty valid. That's kind of different than, how other people have sort of talked about this concept, myself included, in webinars and kind of points of advice. So what do you think about this kind of retaliation concept and how would you kind of strategically approach it?
Yeah, this is my favorite question. So at a high level, I heard the words whistleblowing. In most states, you have 90 days or less to bring a whistleblowing claim. And a whistleblowing is not reporting internally a violation of law. It's actually reporting externally to a governmental agency about a violation of law or being about to report a violation of law. But putting that aside, retaliation is the number one claim in America brought by employees. So an employee makes a good faith complaint and that leader thinks they're innocent and were falsely accused. And from that moment onward, that employee is forever, quote unquote, dead to them, or they're setting them up to fail. They want to quiet fire them by making their life horrible, right? And so what you need to do to fix a perception of retaliation is be aware of this. Have you ever seen that cat that does the paw waving that you see at various stores? That's called the cat's paw theory. So if a leader engages HR and says, go investigate this employee that made a complaint about me, you're just a paw to that leader. You're basically forced to find a way to fire them for performance, when in reality, you're just a paw to the bad actor. So the cat's paw theory story is there was a fox that tricked the cat to move the chestnuts off the roasting fire. The cat burned its paw. The fox ate the nuts and said, I didn't steal them. The cat did. I was just eating what the cat gave me. If you are a cat's paw to the bad actor, that is retaliation. So the best way to avoid a perception of retaliation is to bring in an outside attorney or a consultant or find another employee in the company that doesn't have knowledge of any of this retaliation or inappropriate conduct and does a neutral investigation based on the facts at hand.
But so I would say that it's a best practice, and I get that there's other views on this. She just presented a cogent, fine view as to not poke the bear. I would say I would build in, like, if somebody reports something to me or reports something to HR, I'm definitely following up to make sure that they're not retaliated against, because over 50% of people that speak up face some kind of retribution according to various ECI studies. Okay. And I want to at least kind of communicate that I don't want to stand for retaliation. I don't want this to be a company that this is happening in. I hadn't really thought about poking the bear and how that might sort of give ammunition, let's say, to somebody that still has, to her point, available to them other channels to report all kinds of wrongdoing and all kinds of policy violations, one of which, of course, was most presumably a no retaliation policy. So is it worth, as like a best practice, to say, like, for every report of a certain category or of a certain severity or of a certain, I guess I said category already, or maybe all reports, is it a good idea or potentially a bad idea to build into your process a consistent follow-up at some point down the road? Or does that end up kind of opening you up to too much liability vis-a-vis poking a bear?
I think it's a great idea to have what's called the interactive process and open communication, so both sides know where you stand. But I think to fix this retaliation issue, there's other strategies. One, when you're investigating a claim by a subordinate, you don't even need to tell the person that's accused who made that claim against them. You could say there's a perception that you're engaging in this type of conduct and behavior. I'm not telling you who. Let's talk about it and how you can fix that perception, leader. And in some scenarios, the leader wouldn't know which employee is part of that. Or if someone makes a good faith, claim, maybe ban that person that's being accused from being part of that employee's evaluation process and bring in other parties that don't have a perception of being biased. Even if that manager was being honest, there's a perception that they will be biased.
Okay. Thank you. These are great questions. I'm going to come back to some of those here in a second, but I want to kind of get into, we have about 20 minutes left or so. We're kind of on this retaliation thing. We have a couple more questions on that. So we kind of touched on this a little bit, but I want to go back to it. You mentioned that, EEOC claim, or out of EEOC claims, retaliation remains one of the highest. What do you think we're still getting wrong on this? Is it that there's not that follow-up to kind of keep our finger on the pulse? Is it that there's not a feedback loop? Is it that this differential between, actual, i.e. valid, and perceived, maybe that's not valid, distinction between kind of retaliation? Is it a perception is reality issue? Like, how is it 2026? And I've done a dozen freaking webinars on this, not that everybody comes to them, but I'm saying, like, I'm not the only one talking about retaliation. How are we still talking about it? And how is it still such a large, massive proportion of the claims that come out? Why can't we sort of stop the boat from leaking or whatever?
So there's various statistics that if an employee speaks up that they're not happy, whether it's pay, whether it's their manager or otherwise, they're usually gone within 1 year anyway. And so if they bring a retaliation claim, they're obviously not happy. So, and they're likely to be gone anyway within 1 year, whether it's their choice or the leader kind of forcing them out. So basically anyone that leaves within 1 year of bringing a claim against their company, they're likely going to feel in good faith retaliation was part of the reason that they're leaving or that they were fired.
Yeah.
And so I think in those scenarios, there should be a better process of having a performance improvement plan or 3 examples of clear violations of policy that are happening again, and again, so that that employee is less surprised, or there's a stronger evidence chain supporting that other employees have also been separated for this exact same reason. Don't just analyze the fact at hand. Zoom out and say, have we terminated everyone else for the same performance issues before or not?
Right. So part of that is just kind of kind of doing the homework along the way to ensure that should this come to arbitration or to, a lawsuit or something, you have some objective things to point to that cannot easily be picked apart by opposing counsel. I mean, that's kind of what it's coming down to.
It really is, but there is a timing element here. If you can wait, a year or longer before that person leaves, it makes it a lot less likely that retaliation was the motivating factor, because they wouldn't have put up with someone for a full year afterwards.
So, okay, let's kind of double click on that. Like, how do you think compliance folks should be thinking about the timing and sequencing of adverse actions following a protected complaint? Is that a critical element, like the protected class of somebody making a complaint, documenting that and understanding that? And does that have any kind of influence on, the timing and sequencing of like adverse actions? You know what I mean?
So in many states, timing alone is not enough to be evidence of discrimination. But if you terminate someone the same day they tell you they're pregnant and about to go on maternity leave, I can guarantee you there's a lot of plaintiff attorneys that would line up and take that case. So in the ideal world, you wouldn't terminate anybody within a year of making a complaint unless you have very strong performance issues. So I have had a pregnant employee that I caught stealing. I still fired them because I had clear evidence that anybody would be terminated for that conduct.
Okay. So let's get some kind of practical advice. If you could boil it down to like, what are the first three things a compliance or HR team should do to protect the organization and the employee when an internal complaint comes in? What are some things that we can make sure that we're building into our process? Yeah, go ahead.
So, and there are questions about what are the top 10 mistakes. So because that is the title, I will cover those top 10s after answering this question.
Yeah, so you got to stay tuned. That's the thing. Okay.
That's right. So step one, when somebody is about to make a complaint, it's very important that you do the 7W test, which is who, what, where, when, why. We all learn how to tell a story in elementary school with the 5 W's. And then you need 2 more W's. Witnesses. My daughter has a class clown in her school named Henry. And the teacher asked him, was that you that put a kick me note on the back of that kid? And Henry said, before I answer that question, were there any witnesses? And smart kid. And you need to know the witnesses to verify who is telling the truth and also to allow that employee to be more accountable. But the most important W is the want. What is the solution that employee wants to bring to the table? And if it's reasonable, we could probably just solve it and provide that solution, whether it's a training, a policy reminder, whatever it is, and just be done. But
nobody asks that last one.
That's right. And the reason why retaliation claims are so high is because employees are using inappropriate talk in their complaint. They're saying my boss is an asshole. They suck. They're disrespect. They're using these broad conclusions. They're doing you statements. So they're giving their boss the finger. They're having a lot of emotion in their incident report. I would rather them have no conclusions, no emotion. If you say my boss is mean, rude, a-hole, that doesn't tell me any facts. What does that mean? So I would just stick to honest and non-exaggerated facts, because if you exaggerate or make conclusions that are not supported by the facts, of course your boss is going to hate you. I would too.
Okay, so I love that 7 W's. So I know we started a little bit late. Should we circle into those 10?
Let's just do a quick summary for those that join late. So the top 10 is, number 1 is discrimination, harassment, and retaliation. That bucket is all part of one. That's the most common headache you're going to have to deal with. Another one is misclassification. If you make employees exempt just by giving them a salary, they may not have job duties that support that exempt test to make them exempt from overtime. Or misclassifying employees as independent contractors. 3 would be, how do you deal with leave issues? Employees that are sick, don't show up to work, don't call in the right way. 4 would be how to deal with disabilities, like a health issue, a physical disability. 5 would be like a mental health challenge. The disability laws have expanded so much that a lot of employees are depressed, have anxiety or stress. Maybe the job requires you to have a certain level of stress and be able to resolve conflict. What do you do? And then 6 is wage and hour compliance with overtime, paying them with bonuses, commissions, etc. 7 would be like National Labor Relations Act, the right for employees to have free speech to improve working activity. 8 would be how to handle prescription drugs or recreational drugs or illegal drugs. 9 would be this type of whistleblowing that we've talked about in the workplace. And then 10 would kind of wrap up with culture and not being clear and doing the 60-day, 90-day check-in to make sure that you're honest and following your culture. And there's strategies of how to resolve each one.
Yeah, but this is where it kind of boils down to. These are kind of the 10 landmines or the 10 areas that really drive a lot of these types of issues that end up creating liabilities, that end up wasting, I don't want to say wasting time, but they're not things that you're planning for. So you're kind of reacting to them. It's something sort of outside the organization that's happening, obviously maybe spurned on by a lack of policy or a lack of consistent training or a lack of kind of harmony in terms of like leadership or, management across the organization. That are some smart places to kind of start to look. So let's talk. So thanks for that. If anybody has questions, of course, keep those coming. There's so many in the chat. I will circle, to those here in a second. I want to talk a little bit about strategic positioning, whether it's compliance or it's HR. We want to, everybody on this call, they want to be a partner to the business. They want to be, strategic advisors to the business, right? We want to improve the company. We don't want to hold the business back. We don't want to be kind of a barnacle on the ship. How do you think we make the case to leadership that, proactive employment law compliance is a business investment and not just a reactive legal cost?
So I actually switched my practice. I haven't been to court myself in over 15 years because this takes one lawsuit where you're spending over $100,000 in legal fees. Think how many years of trainings and proactive conflict resolution tools you could have invested in that are a couple thousand a year.
Right.
It would take 50 years before you spent more money on that than one lawsuit. So I'm seeing that companies are now allocating 3% of their revenue toward training, compliance, proactive measures every single year. And you are getting ROI. Happy chickens lay more eggs. If you can make the employees feel like you're investing in them, they can be up to 50% more productive. So a 50% return on your bottom line is actually a money saver as opposed to a cost center.
So what do you think what do you think is one sort of practical conversation that ethics, compliance, HR, professionals on this call should be having with their legal or executive team that they're probably not having right now? Either because they haven't thought about it from the kind of some of the frames that you presented today, because they're living in reactionary mode. What do you think there's, what's one of those conversations to start having?
Yeah, the first conversation is, hey, what training did someone that manages people have in the past year? And if the answer is none, that is a huge landmine. We've all probably heard of Marcus Buckingham, and he said 101 of managing people, if you were to survey them, at least 10% of them would say they hate managing people and don't want to. They just got forced into that role based on their tenure or based on having a good skill set in something else. And if you're not checking in once a week individually with anyone that reports to you and saying, how's it going? How can I help you? You should be fired. You're not managing people if you're not at a minimum doing that once a week check-in. So I think that we should review at a minimum job descriptions. Most job descriptions don't even identify a leader's role in growing people and managing people and checking in and interacting with people. And we need to revamp the people focus of all leadership positions.
Yeah, it's It's a whole new skill, right? I mean, just because you're a great kind of individual contributor, becoming a manager is not kind of a foregone conclusion. It's a whole new skill. It's a whole new set of kind of techniques that somebody needs to develop. And that continues to happen across, companies.
It does. And it's very easy to have a train the trainer. So even if they don't have the budget to spend training on every manager, at least invest in someone that could then internally train other people within their own organization.
Okay, so we're going to go a couple minutes long because of my camera issues here, okay? And we got a ton of questions in the chat. You want to just start hitting some of those off? Are you good with that?
Yeah, bring it.
Okay, sweet. Okay, so let's start with Brittany. Great question here, Brittany. Appreciate this question. Are there cases where an organization's own compliance training materials or communications were used against them in court? What should communicators and leaders learn from that? Great question.
The answer is yes. And it's because some training materials say you have to follow these steps before you take an action. So you never want your employee handbook or training materials to say what the employer is going to do. It's more rules of what the lower level employees are supposed to do, because if you put that in writing and the executives don't follow it, well, then they can be held accountable for not following their own rules. If you're going to have those materials, if I prepared them, I would make it clear that in many scenarios, you need to skip steps. All fact patterns are slightly different, and there's no liability for, in good faith, not following the manual based on exceptions.
Yeah. So I think what you said there is kind of important. I think sometimes, there's always this kind of line of like transparency and opacity that we're trying to balance, right? We want to be transparent because that builds trust, but we don't want to violate somebody's confidentiality, right? We want to show that, we're doing things about, the things that are coming through our hotlines or the complaints that are being made. But again, we don't want to, violate the anonymity and things like that, right? So I find that most end up kind of leaning on the side of we just won't tell anybody anything. And I think that can kind of drive a level of distrust or a lack of engagement from the employee base. So what I like about what you just said is that you can give people some kind of a picture about a process, or you can give them some kind of a picture about what they could kind of come to expect from a reaction from the organization. But by putting that asterisk on there, you're not creating like a liability that might be kind of that you're going to get your face rubbed in should something kind of go off the rails.
You're right. It's mainly a sixth sense training. I want you to spot more issues than you currently were so that you can then be smart and handle them appropriately.
This is a great question. How would you deal with a manager who's a top performer in terms of KPIs and deliverables, but is too stressful and harsh, sometimes even aggressive with employees? Some employees are resilient, but others cannot stand it.
Yes. So in the modern workplace, those leaders are starting to be fired more and more. It sets a great tone for culture that even if you're a rock star, but you don't fit in our culture, we have to let you go. But before doing that, I would invest in that rock star and provide them with training and give them tools to see if they're capable of growing into your culture, because they probably got to where they are by acting that way. So it may be a surprise to them to all of a sudden be held accountable for the first time.
Yeah. It's crazy though. It's like, people can kind of get away with that a little bit, and then they think that it's fine. And then it's kind of creating a whole sort of toxic, subculture within the broader organization that sends in most cases, it sends like a big conflicting message on what's acceptable and, whether the broader values, the words on the wall, so to speak, are even real or not. Like as that distance between that actual culture and the aspirational culture kind of grows and grows, these words on the wall turn into platitudes, and it's like, well, this whole thing is a joke. And then everything, I can't trust anything that the organization says. Right.
You'll lose all your credibility, or see if there's a role where they don't interact with people anymore and they're just out working remotely being, that specialist in the area that they're actually good at.
Yeah. Dirk has a great question here. What I hear a lot from management and HR is, we are letting you go because of corporate restructuring. The reality is there was no negative performance review or any other negative employee issue. Management wants to let them go because they filed an internal complaint or pointed out internal wrongdoings. HR merely rubber stamps the decision, or is that sort of cat's paw? How would you handle that?
Yeah,
Great
so
question.
this
Thanks, Dirk.
concept of rubber stamping in HR is a bad idea. I'm seeing the same concept apply with AI. Oh, AI told me I should fire these people. Well,
Right.
you don't know, you're responsible in HR to know all of the algorithms the AI is factoring in. Likewise, you're responsible to know all the algorithms the manager, the other people making the decision we're factoring in. Otherwise, you essentially are just exposing your company to liability because you may allow them to use illegal reasons as part of their basis in making that decision. And you don't want to be deposed in a lawsuit and say, why did you fire this person? Oh, I have no idea. I'm just a rubber stamper. I don't think that's going to go well for your brand and reputation.
Yeah. And I mean, if it gets to that point and you're saying, oh, there was a restructuring and it's just restructuring of one person, it's not kind of restructuring, I don't think.
That'd be my example of never give a false reason. You at a minimum HR need to verify the reasons given, if any, are accurate.
Yeah. Letitia's got a great one here. Thanks for this, Letitia. With respect to retaliation, what are the implications when an employee who is aware their employment may be ending and initiates a whistleblower claim in an effort to safeguard their position? How can a manager who has been accused ensure they don't face retaliation claims while still overseeing an employee's performance? Great question. That's a hard one, man.
This is a very common scenario. So let's say you're that good employer and you give that employee the 3 strikes, and then you say, come meet me on Monday. Well, yeah, on Monday morning or just before it, that employee is going to bring up a whistleblowing claim, skeleton in the closet, or they're going to bring up that they have stress, anxiety, and depression because they're about to be fired. And so then you as an HR or a leader are like, my purpose of this meeting was to fire them. Can I still fire them? And the answer is, if you have an email chain that the purpose of your meeting was going to be to fire them, or you already have some notes at a board meeting that you've decided to fire based on legitimate performance reasons, you still can. But if you don't have any paper trail or email trail or anything, it would look very suspicious to say they have a performance issue the same day they did a whistleblowing claim.
Yeah,
but
right.
Your fact pattern is relatively isolated on whistleblowing because they typically have 90 days to raise that skeleton in the closet. They can't raise something that was 3 years ago.
Okay. So I loved your model of the 7 whys: who, what, where, when, why.
Who, what, where, when, why, witness,
want. So let's kind of give some examples of what like a valid want is and how that could be better built into the investigative process or the whistleblower hotline process, right?
So a typical want is, let's say my boss is an a-hole. They don't always want their boss fired. They may just say, can we provide a training for that boss so he doesn't do it again? Can we do a policy reminder to the whole department so no one's singled out or feels like they're bullied or picked on, to see if that improves the behavior? Can we share a few examples, hypotheticals that are probably true and hit close to home so people can be more self-aware of what they're doing is inappropriate? So a want like that would be easy. Or let's say they want too much. I have diabetes and I want organic orange juice with an ice chilled, deep sub-zero freezer and refrigerator in my office. And I want to be able to have an ergonomic assessment to see if I have enough natural sunlight and my desk is the right height for me to stand up. Once they give you a solution, you don't have to just say yes. You could say, oh, you want to stand up? Okay, let's raise your monitor. Oh, you get a sugar low, take a 10-cent sugar pill. You don't need orange juice. So like once they propose something, we then at least have something to work with to make the want reasonable. Like I had someone come to me and say, hey, I want to take 2 hours off midday to go work out because I'm happier. I said, I am too, but guess what? Why don't you do it in the morning or at night? So sometimes the want, it's always up. If an employer proposes a reasonable want that is also reasonable what the employee asks for, the employer always wins. You don't have to give the employee what they want. You just got to give them some accommodation if there was a legal requirement to do so. But even if there isn't, it may be the right thing to do to make them a better employee.
Well, I mean, it's such a smart move. That seventh W is so great because, kind of to your point, like we as human beings, we have this negativity bias and we fill in the gaps with the worst case scenario. And usually the want is not a worst case scenario. Like they're not saying I wanted $1 million raise this year. It's going to be something probably that from, if you assume everyone is sort of a reasonable actor, it's probably going to be something that you can do something with, or at least get the information to see kind of where somebody's head is at. But instead, it ends up being this sort of chess match or this kind of poker game or something where, nobody wants to show their cards and I don't want to ask it and all these kinds of things. I think it brings a lot of, it helps to humanize the process. It probably builds a lot of trust by just being willing and building into your process a willingness to like hear what somebody wants. And it gives you a ton of extra information that you can, make your moves accordingly.
You're exactly right. And there's a lot of creative solutions that you can come up with. When someone wants the corner office for natural sunlight, and let's say that's not feasible, you can let them have a light box on their desk that makes them happier. Or if someone says they want to work remotely because they get distracted, well, you can give them earbuds or have a blinder wall up to allow them to be productive at work. So there's a lot of creative solutions to solve problems.
Awesome. All right, James, let's get one more massive emoji explosion for James. This was so much fun, man. I feel like I learned a lot. I got a lot of things that I'm consider them stolen. That seven W's, I absolutely loved it. You've been a great guest, and the chat, says as much. So appreciate you so much. Where can people find you and contact you and all that?
Yeah, I would love everyone to connect with me on LinkedIn. I post legal updates regularly. If you want to get on my mailing list, send me an email and would love to keep the conversation going.
Well, I absolutely learned a lot. People absolutely loved it. And we got 2 great sessions next week that you're not going to want to miss. We got the one and only Ross Ronan coming on Tuesday. So whether you're in healthcare, this is going to be a healthcare session, of course. But if you're in healthcare or not in healthcare, you're going to learn a lot from Ross. He is phenomenal. I've learned so much from him. And then next Thursday, we got another banger for you. I think it might be another Matt Kelly session. So Ethicsverse continues to try to give more value to the market because what got us here is not going to get us there. We have the opportunity to turn our function into a real strategic lever in our organization, but it's going to take us doing things a little bit different. Small tweaks to the way that we're engaging, small tweaks to the way that we're building relationships and building impact in our organization start to compound in significant ways over time. So thank you all. Thank you for the chat. Happy Easter to all of you, and we will see you next week.